Cambodia. She was also co-counsel for Radovan Karadzic on appeal before the International Residual Mechanism of the Criminal Tribunals, in addition to representing accused and victims in 2007 and 2008. Kate was the Associate Legal Officer of Judge Mohammed Shahabuddin in the Appeals Chamber of the ICTY and ICTR. And lastly, in 2018, she was appointed as a legal consultant to the UN Independent International Fact-Finding Mission for Myanmar. She holds an LLM in International Law from Cambridge University. And so I would like to give the floor to Kate. Maybe, Kate, you can give us a background of how is it that we arrived at this decision, and what are Mr. Bemba's defense team initial reactions to the decision, and particularly what options remain available for Mr. Bemba at the court or in other legal systems, and very broadly, what may be the lessons learned from this case in the context of the ICC review process that could be drawn for the purposes of maybe identifying potential areas of strengthening the court.
Thank you very much, Ricardo, and thank you to the World Federalist Movement for hosting this event. It's a really important topic, and it often doesn't get a lot of airtime, so thank you for giving it some. Just by way of background, Mr. Bemba was arrested in May 2008, and he was detained for a little over a decade before he was acquitted by the Appeals Chamber. And it was a decade that was quite significant. It was a period of time in his life where he could have expected to be sort of at his peak professionally and politically, but more importantly, and I think he'll agree, it was a very significant decade for his family. Mr. Bemba is the father of 5 children. His youngest son was, 8 when he was arrested, 18 when he was released. So Mr. Bemba really missed that part of his life. He missed his children growing up, and that's gone now. He won't be able to get that back. So when he was acquitted, we filed a claim on his behalf in front of the ICC, really trying to repair, in a way, some of the damage that had been done to him and to his family by this sort of continual 10-year period of incarceration. And it's important to note that Mr. Bemba filed many requests for provisional release during that decade to his family home, which was 2 hours from the prison. All of those were unsuccessful. So you had a situation where there were other defendants who were at liberty during their proceedings, and indeed occupying positions within the Kenyan government, whereas Mr. Bemba was released for a period of hours during the 10 years to attend the funeral of his father in 2009 and his stepmother in 2011. So under the ICC statute, there are 3 situations that can potentially give rise to a compensation claim. The first being where there's been an unlawful arrest or detention. The second, where a final conviction has been reversed on the grounds that a new or a newly discovered fact demonstrates conclusively that there's been a miscarriage of justice. And then the third limb on which we hung Mr. Bemba's claim, which was that there's been a grave and manifest miscarriage of justice, which gives rise to a discretion on the part of the court to order compensation in exceptional circumstances. So, while this idea of compensating acquittees was sort of heralded as this great advancement in the Rome Statute and this huge improvement on the ICTY and ICTR, in fact, it's difficult to think of a higher threshold, in exceptional circumstances only, and a grave and manifest miscarriage of justice, not just any miscarriage of justice, not a run-of-the-mill miscarriage, but a serious, grave. It's clear that the drafters were trying to set the bar very high, that they wanted this to be a difficult thing to establish. And we argued on behalf of Mr. Bemba that, in fact, the trial proceedings in front of Trial Chamber 3 had been so flawed and the trial process so badly managed that it interfered with his rights as an accused, which gave rise to a grave and manifest miscarriage of justice. And the pretrial chamber assigned to hear this claim for compensation decided, as you said, on the 18th of May, that Mr. Bemba had not met the threshold and was not entitled to compensation under Article 85.3 of the Rome Statute. But there is a second and fascinating aspect to the claim brought by Mr. Bemba, which relates to the seizing and destruction of his personal property and assets. Because in May 2008, when Mr. Bemba was arrested, that wasn't the only thing that happened. The prosecution asked the pretrial chamber to seize and freeze all of Mr. Bemba's assets in the DRC, in Portugal, and in Belgium. And the pretrial chamber said yes, and it issued requests for cooperation to those 3 states, and everything was frozen. And not just Mr. Bemba's property, but also property belonging to his family. So property of his wife, of his brother, and in some instances of his children. It's a huge deal to freeze someone's property and to take and freeze their assets. In my jurisdiction, freezing orders are referred to as the law's nuclear weapons because they're so draconian and give rise to such serious consequences and such onerous legal duties on the person who asks for them. Central being the obligation to preserve and maintain the value of the property, to look after it properly so that it maintains its value. And that's, uncontroversial. That's a universally accepted principle. There's a lot of jurisprudence nationally, internationally. You can't just freeze someone's property and leave it. Because if your claim is unfounded, you have to return it to the person in the same state in which it was frozen. Or if your claim is founded, then you have a legal right to that property. So you're not just going to freeze it and leave it alone. In the case of Mr. Bemba, it was the victims who were intended to be the ultimate beneficiaries of these freezing orders and of this property. So what happened? 2008, everything gets frozen and nothing is done. No steps are taken to even attempt to try and preserve or maintain the value of this property. Mortgages aren't paid and are defaulted, taxes, VAT, parking fines aren't paid, businesses are left, and in the case of the DRC, physically dismantled, the houses or no houses are maintained. Mr. Bemba's family car is impounded in Portugal and it just rusts. Nothing is done, and all the while Mr. Bemba is pleading with the ICC, please maintain my businesses, please keep this income stream alive so I can at least pay for my defense, so I can pay for my lawyers. And nothing was done. And on his release, Mr. Bemba engaged a firm of forensic accountants to try and quantify the economic loss that had been sustained by these freezing orders. And that firm put the damage conservatively 18 months ago at 42.4 million euros. So if you think about that in the reverse, if Mr. Bemba had been convicted, if his conviction had been upheld on appeal and not reversed, the trust fund would have been assuming losses to that extent. The trust fund would have been liable to pay the 700,000 euros that were due in VAT and parking fines on the plane that was abandoned in Portugal. So putting Mr. Bemba and his family aside, it's the victims in whose name this was done that have the biggest reason to decry this negligence. And it is negligence. And that was the second half of Mr. Bemba's claim. Seeking damages for the economic loss suffered as a result of the ICC's negligence in freezing and failing to maintain or preserve this property. What did the pretrial chamber say? In the same decision on the 18th of May, the pretrial chamber said, that it didn't have jurisdiction to decide the claim. The pre-trial chamber said that when the ICC presidency assigned Mr. Bemba's claim to it, it only assigned that aspect under Article 85.3 in relation to detention and not the larger claim for damages. And in the year that it took the pre-trial chamber to decide that it couldn't decide, Mr. Bemba's property in Portugal and Belgium is still frozen and the losses are continuing to accrue. And to me, the most significant part of this decision is that even though the pre-trial chamber said that it didn't have the ability to decide the question, it still found that it was able to go on and attribute blame for that to the states. So in paragraph 57 of the decision, the pre-trial chamber says that responsibility for the proper execution of requests for cooperation from the ICC rests primarily with the states. And it was really surprising to us that the pre-trial chamber would go there to sort of say, we can't decide this claim, but if we would, it'd be the state's fault, because it really sets up this huge chasm, you know, between the states and the court. And I think it'll give states a lot of pause when considering whether or not to cooperate with the court in the future, if this is the view of the court in relation to liability when things go wrong. And so what does Mr. Bemba do now? What happens next? Last week, or the week before, I think we sought leave from the pre-trial chamber to appeal their decision to the ICC appeals chamber. So the proceedings are still ongoing at the ICC. And the pre-trial chamber in its decision was explicit that its ruling was without prejudice to any other avenues that Mr. Bemba could pursue in other jurisdictions. And of course that's right. Mr. Bemba has the right to sue to recover this damage in domestic courts in Belgium and in Portugal and in the DRC. And we imagine that it's likely that the states would then join the court as a party and seek to recover the damages from the court in that way. So a very long and complicated, multi-jurisdictional road ahead in which the ICC will almost certainly be a party. And in order to try and avoid that nightmare scenario in which we may find ourselves, we suggested in the claim that a sensible solution might be for Mr. Bemba's claim to be submitted to binding international arbitration, whereby Mr. Bemba and the ICC and the states would agree to be bound by the outcome. But that we haven't been taken up on that offer. I think Mr. Bemba sees the pre-trial chamber's decision as another step in a very long process of him eventually being put back in the position he would have been in had his assets not been frozen and destroyed. But this happened to him. And no one is saying it didn't. You know, not the pre-trial chamber, not the registry, not the states, not the court. No one is saying to him, no, actually, we did pay your mortgages and your businesses are all thriving and your houses have been maintained and here are the keys to your car. It's no one could sensibly make submissions along those lines because this happened. And as much as we would love it and as much as he would love it to just go away, it's not going to. When the ICC makes mistakes, it's not immune from consequences. In terms of the third part of your question being lessons learnt from the predicament in which Mr. Bemba now finds himself, it's very clear to us from the internal documents of the ICC that it was known that this was going very badly wrong. The ICC knew that this adventure into freezing orders was going pear-shaped badly from early on. And there's this 2016 internal report from the court about the registry functioning, which we cite too liberally, I will admit, in our claim, that talks about the registry's grossly insufficient inability to deal with state cooperation and refers to the registry as acting at best to perform routine tasks in damage control. So there's a fix, isn't it? To, I don't know, hire people or train people who understand the legal obligations that come along with the extreme step of taking someone's assets and livelihood from them. But to me, the real risk is a different one, which is that I think this decision, this situation in Bemba might spell the end of freezing orders at the ICC for many reasons, but a significant one being the 18 May decision. Because the pretrial chamber is really saying to states, if you execute a request for cooperation from the ICC and anything goes wrong, you are liable. You are liable for anything that happens next. And why would states take that on? Why would they assume that huge financial and legal responsibility to manage the assets of an accused, knowing that if the businesses devalue or the assets some way go down in value, then the ICC is going to send an acquitted person directly to the state to sue them? I think it raises real questions about whether or not states would be willing to engage in this, particularly in the current form. So for me, you know, I worry or I think that this might spell the end of the road for freezing orders at the ICC, but it's not the end of the road for Mr. Bemba, and he still faces a significant and litigious long road ahead to try and claw back what was taken from him. I obviously have a lot more I could say about this, but I see the time and I'm very happy to respond to the other panelists or respond to questions later in the talk.
Absolutely. Thank you very much, Kate. And you raised many very interesting points, and especially on the impact that this can have on cooperation and how it could potentially backfire for future freezing orders. We're going to turn now to Dr. Doug Jacobs. Dr. Jacobs is currently a senior legal assistant on the defense team of Lauren Bagwell, the International Criminal Court. He has been an active member of the ICCDA since its creation, initially on the training committee and this year on the legal advisory committee, with the belief that the defense needs strong institutional presence at the ICC in order for their voice to be heard and their needs to be addressed. Dr. Jacobs has over 15 years of experience in international law, international criminal and human rights law, both as an academic and as a practitioner. Having obtained a degree from King's College in London, a master's degree from Sciences Po Paris 1 and Paris 2, and his PhD at the European University Institute, he joined Leiden University as an assistant professor in 2011. He has been teaching international criminal law to generations of university students, as well as done training for professionals for many years, in particular in the context of the ICCDA. His publications confirm his experience in ICL and ICC. They have touched upon fundamental procedural issues such as admissibility, the rights of the defense, and scope and definition of charges, immunities, or provisional release. And he regularly comments on ICL issues on his blog, Spreading the Jam. And so, Dr. Jacobs, I would give you the floor maybe by asking you, well, of course, what are your views on this decision, considering, for instance, that the trial chamber recognized that the time spent in custody by Mr. Bemba was significant, likely to result in personal suffering, and would trigger compensations in many national systems for violations of the fundamental fair trial right to be tried expeditiously. And so, particularly, what do you think may be the legal policy or practice reforms which, if implemented, would strengthen the court and the Rome Statute system in relation to the rights of the accused and the acquitted in the context of this decision that has just been issued by the court.
Okay, thank you, Ricardo. So obviously I have to start with a usual caveat, which is I'm speaking here in my personal capacity and not in the capacity of a member of a defense team or a member of a university or any other capacity. So also it's difficult to speak after Kate, obviously, who's covered a number of issues relating to the decision. But I'll try to build on what Kate said and provide some comments on the reasoning of the chamber on a number of points before addressing your questions, Ricardo. So as Kate said, there are two claims in the decision, in the request, and while everybody is focusing on the reparations claim relating to assets frozen, etc., I find that the reasoning of the chamber in relation to the first part of the claim is quite problematic moving forward. I'd like to focus on that for a second, and we can come back to some details in the discussion, but I just wanted to highlight just a few points which are problematic. The first one is the standard that the pretrial chamber considers, and as Kate pointed out, it's textually, literally a very high standard. It's exceptional circumstances. It has to be not just any miscarriage of justice, and also the pretrial chamber is very clear in saying even if all that is established, the pretrial chamber has a discretion or not to give reparations. So even if you've established exceptional circumstances, a grave and manifest miscarriage of justice, there is still a space of discretion for the pretrial chamber not to issue compensation. Now, obviously, like often in those kind of decisions, we don't know when that would be. I'd like to know concretely, I'd like an example, where the pretrial chamber, having established a grave miscarriage of justice, nonetheless decides I'm going to use my discretion not to issue compensation. I'd like a concrete example, and I would like some information from the chamber, factually, materially, when that would arise and be okay. So that's the first point, is the discretionary dimension. The second problematic dimension of this decision, and if you read it carefully, is, and this is something the defense team of Mr. Bemba are raising in their request to appeal, you cannot raise in an Article 85(3) claim anything you've raised during the trial. That's very clear. If you've complained about something during the trial, you cannot raise it in an Article 85(3) proceedings. This is incredible for me, logically speaking. So basically, if you're diligent as a defense team, and as the trial is going along, you raise before the chamber some problems in terms of fairness, in terms of miscarriage of justice, which is your job, basically. If you don't do it, you're going to be told you didn't do your job. But then you cannot raise it under an 85(3) claim at the end of the trial. Again, this is crazy because you're basically documenting the ongoing miscarriage of justice. The fact that it's been dealt with is not an answer. This is the whole point of the matter. If you're raising unfairness before the trial chamber, and the trial chamber keeps saying, no, I'm not unfair, then it just kills any claim at the end. It's completely illogical to bar a defense team from raising issues at the Article 85 stage, which they already raised during the trial. And apparently this is, established case law from the Ngujolo case, and I don't understand how any, legal assistant or judge could approve that, because again, it makes no sense, logically speaking. So I think that's the biggest problem with the decision, in fact, in terms of what threshold is required. Evidentiary threshold is required from an acquitted person to reach a level of compensation. The third point that's interesting is the pretrial chamber is very clear in saying that not all acquittals are per se miscarriages of justice. And I think we can all agree on that, probably. However, the way it deals with what happened concretely in the Bemba case, and I don't want to overstep my function, and Kate can correct me if I'm wrong, but again, the defense team didn't claim that the acquittal per se is a miscarriage of justice. The defense gave specific examples of the conduct of the trial chamber, of the type of evidence it would use, of the ex parte nature of some discussions on defense witnesses. And again, I'm not expressing an opinion here, but clearly the defense made an effort to raise exceptional circumstances under Article 85. So we don't have a very clear idea from the decision what kind of threshold would be acceptable. And this is problematic moving forward, because it's very well to reject a decision, a claim, but if you don't give clarity, that's often a problem at the ICC, is that, and usually it's a problem with the appeals chamber, is that they give very vague references to why a claim doesn't work, why a request is rejected, but then they don't give you concrete elements to give you basically legal certainty for the next defense team, for your next claim. And here it's the same, because they rejected most of what the defense said because it had raised it before, we actually don't know what kind of threshold will be accepted. And so this decision provides very little clarity moving forward. But one thing which struck me in that respect is when the pretrial chamber says that it made a comment on the appeals chamber decision, which I found a bit strange because it's still, an appeals chamber decision. And it says, the chamber is aware that Mr. Bemba's acquittal was based on a standard of review which far from being uncontroversial, split the appeals chamber, triggered the dissent of 2 judges, and led to questioning its consistency with the statutory framework. Now, and then says later on that the majority never referred, whether implicitly or explicitly, to the existence of a miscarriage of justice, even less a grave and manifest one, etc. Now, I find that problematic because the reality is that a dissent should not change the nature of the reversal of the conviction to such a large extent. That commentary about the standard of proof, I think, is problematic. There are no footnotes, so I don't know, which commentators or those who follow those matters know who criticize the judgment, but I find it's not the place in a pretrial chamber decision to refer in a vague way with 0 footnotes to a controversy about the standard of proof. And probably more importantly, I think that their reference to the appeals chamber majority judgment is a bit misleading, because if you look at the judgment itself, paragraph 40 explicitly says that the appeals chamber's intervention is to prevent a miscarriage of justice. And it's not because the appeals chamber corrects on appeal a miscarriage of justice that it didn't exist in the first place. It cannot be that because an appeals chamber does its job by reversing a trial chamber decision, that the whole time when the trial chamber decision existed and the whole trial itself, this does not, make it disappear. That period of time can be qualified as a miscarriage of justice. I'm not saying it was, but by the logic of the appeals chamber, it was. Paragraph 40 of the appeals chamber judgment, it explicitly mentions a miscarriage of justice. The Judge van den Vargert and Judge Morrison's separate opinion, they are very clear about, not just a basic error of fact or law. They criticize the trial chamber for having a complete disregard for the standard of proof beyond reasonable doubt and the presumption of innocence. That's not your run-of-the-mill error of fact or error of law. If you look at Judge Osuji's concurring opinion, he also justifies the intervention of the appeals chamber. I think the word injustice appears dozens of times in his concurring opinion, and he explicitly explains that the intervention of the appeals chamber is justified to avoid a miscarriage of justice on appeal. So I find this disingenuous from the pretrial chamber here to say, no, they never mentioned it. No, they explicitly said they were intervening to correct it. They didn't make it disappear. So again, I find this problematic from their perspective, even logically. Now, coming to the reparations part, I don't have much to add to what Kate said, just two comments. The first one is, I find it interesting that the pretrial chamber claims that, the registry is just acting as a go-between between the court and states. But it doesn't mean, this doesn't justify why the court is not responsible. It justifies why the registry as an organ might not be responsible. That's the first point. Second point, it's interesting to see how the court wants to have its cake and eat it, because if you recall the immunities judgment, the appeals chamber in the immunities judgment was very happy to claim, oh, when exercising a cooperation request, states are just acting as the agents of the court. They're not acting as states. So someone who's a non-state party national cannot invoke immunities, and the state arresting that person cannot use public international immunities because the states have no willpower in that respect. I'm sure you all remember that. They just, again, executing the will of the international community and the court. But suddenly, when it comes to freezing assets, which is technically under the same cooperation obligations, no, states are responsible for everything. They are responsible. The court bears no responsibility. So which one is it? It can't be that when we want to remove immunities, states are the simple agents of the court and have no conscious will or agency, to put it in simple terms. But when they're executing a freezing order, then the court is responsible for nothing, and the states are acting autonomously and are responsible for everything. It can't be both, and it can't be that it's only when the court is happy with the conclusion that it can decide. So there's a problem there. And a last point, moving forward, I think that on the first part of the claim, I've always found it strange when judges comment. They act not as judges, but as commentators, like I mentioned before about the appeal judgment, but also at the end, this call for state parties to reform the statute. I've never, maybe I'm too rigid, but I've never thought this was an appropriate avenue for calling for reform. And it's not the first time it happens. I've seen that many times in the past. We regret we can't do this. Please, state parties, change the, So I find that a bit strange. I honestly believe that Article 21(3) of the Rome Statute could have allowed the pretrial chamber to interpret Article 85(3) liberally. Applying Article 21(3) is not incompatible with the drafting history. I cannot question what the pretrial chamber says about the drafting history and the fact that states hesitated between automatic compensation, etc. I won't go into that detail, but ultimately, that's a different mode of interpretation than 21(3). So I think there was no obstacle, technically speaking, for the pretrial chamber to ignore, let's put it simply, the drafting history and interpret Article 85(3) in a more liberal way. I think they could have done that. And the last point on reparations now, I'm sure Kate and her other counsel of Mr. Bemba will be aware, but I worked for many years on a project at University of Amsterdam called SHARES, on shared responsibility in international law. And how the responsibility of various international organizations, states, individuals might interact under public international rules of responsibility. And obviously, when I see this situation, I'm salivating because this is a perfect example where you might have the responsibility of the ICC as an international organization, the responsibility of individual states acting both as agents of the IO, but also acting under their own domestic law to execute an arrest warrant, possibly the responsibility of negligent individuals in various countries. So I really look forward to see how this moves forward and becomes another practical implementation of shared responsibility under international law, because this could be an amazing test case for the future. Okay, I think I'll stop there and give the floor to the others, and I'm happy to pursue this conversation in the Q&A afterwards.
Thank you, Dr. Jacobs. Also made very interesting points on how the trial chamber reasoned its decision and comparing to precedent and other decisions from the appeals chamber in the past. I will now introduce Mr. Xavier Jan Keita and Mr. Michael Hertz. Then I will give the floor to Mr. Keita to start their presentation. So Mr. Keita joined the ICC in 2007 as principal counsel for the defense office, the OPCD. He has practiced law for more than 35 years as a member of the Senegalese bar and with the appeals court of Paris. Mr. Keita was a founding member of the International Criminal Bar and the International Center for Training Francophone Lawyers in Africa. He has chaired the first Lawyers Union of France, the Commission on Admissions of the French Bar National Council, and the International Human Rights Commission, together with SOS Avocat of the International Association of Young Lawyers. Mr. Keita is also an active member of the International Conference of French-speaking bar associations. He's an international law expert, member of the French Institute of International Law Experts in Paris, and is a qualified mediator. Mr. Keita was also a first instance judge of the complaints court at the International Organization of La Francophonie. He has been appointed as duty counsel for Germaine Katanga and Narcisse Arido, assisted in the first appearances of Jean-Pierre Bemba Gombo, Laurent Gbagbo, and Aimé Kilolo, and was appointed as counsel for Saif Gaddafi for 18 months and was appointed counsel for Mr. Yekatom. Mr. Keita has participated in several conferences, presentations, and seminars worldwide, including in Africa, Asia, America, and Europe, and has lectured for the Asser Institute in The Hague University, the New York Bar, the Paris Bar. He has published articles including with the IBA Equality of Arms Review, the Institute of Security Studies, and the International Association of Young Lawyers, and has provided commentaries on articles 67 and 55 of the Rome Statute. Mr. Keita was elected member of the Executive Council of the International Criminal Court Bar Association and is the former secretary. And he received medals and awards from the Val de Marne Bar, Paris Court of Appeal, from the French National Bar Council, from the International Criminal Court, and from the African Federation of Young Bar Association. So without further ado, and let me introduce also Mr. Michael Hertz at this point so that they can continue their presentation. And Mr. Michael Hertz, he was called to the Bar of England and Wales in 2010. He has worked in international criminal law for over 10 years, including for the past 3 years as legal officer at the OPCD at the ICC. Prior to this, he was on the defense team of Charles Taylor, former president of Liberia, at the Special Court of Sierra Leone with co-panelist Kate Gibson. And he was a senior consultant for the defense team of In Cham at the Extraordinary Chambers in the Court of Cambodia. He was also an associate appeals counsel for the prosecution of Giramas Suhuko et al. And Sabon Limana at the ICTR, and an associate legal officer for the appeals judges at Perlich at the ICTY. So now, without further ado, I give the floor to Mr. Keita initially, and then for Mr. Michael Hertz to continue with the presentation on behalf of the OPCD. Mr. Keita.
Thank you, Ricardo. I will start first to thank the whole Federalist movement for this invitation and for this interesting topic a few days after the Bemba decision. Usually NGOs wait for a final decision to organize a discussion, and I think that it's good sometimes to be proactive and to look for a remedy or amendment, and to try to be in advance. So I will say first that as principal counsel of OPCD, which is the independent office belonging to the ICC, we are independent, and Michael and myself today are going to speak on the name of ourselves, in the name of OPCD. We are not going to talk or to represent the ICC. So I will make some general remarks about this issue, because ethically we have to know that my office is not entitled to talk at the place of any of the defense team when a counsel or a team have been freely chosen. And I'm happy to be in this panel with Kate, and together with Dov Jacob. I agree 100% with what they have said. I will add some remarks. The first one is that you were talking, Dov, about miscarriage of justice. Unfortunately, we have no definition in the Rome Statute of what is exactly miscarriage of justice. We should have. We have no definition of what is what can be exceptional circumstances. That's the main issue. Two other key points. Should we have to seek for a remedy after this damage? I think the best remedy is not to have to seek for a remedy, and to have in mind the main principle. People facing procedure in ICC, accused and suspect, they are presumed innocent until being finally convicted. They are presumed innocent. This is Article 66. This is the main point. The main point, because we need to have in mind that if at the end of a procedure someone is acquitted, it's difficult to have, even with a compensation, a full remedy. You cannot repair the damages on the family, on the suspect, on the accused. You cannot. It's impossible. So we should use what Kate was calling nuclear weapon. We should use that with a lot of precaution. And my suggestion is to use it when it is absolutely necessary, unless it's better to avoid to enter in the research or search of remedies, because you cannot never and ever repair all the damages on the accused and the family as well. So you have one person tried and you have several victims around. As OPCD, we have been invited by a chamber to give our point of view about freezing assets. We have been very clear to consider that the text itself said that if we can freeze assets, freezing has to be linked to a crime or a product of a crime. And the French version of the Rome Statute is more clear. Les produits liés au crime ou ayant un lien avec le crime. What does it mean? It means that you can freeze assets only if you have a crime. And to have a crime, you have to wait for a conviction and a final one. So by freezing the asset, taking those precautions, we are simply violating the Rome Statute itself and violating the presumption of innocence. The second main point I want to underline is that freezing assets goes with power. And it's through the cooperation that ICC is trying to freeze the asset. We do not have police in ICC. We do not have army. So things work only with cooperation. You have to count on states. So when you have such a big power, a huge power to freeze assets of people, of family, and I totally agree with Dr. Jacob, you cannot have this power and being totally immune of any responsibility. No responsibility for the state, no responsibility for ICC. Is it acceptable through this proceeding or a system when a court is supposed to fight against impunity? Is it normal to organize its own impunity or impunity of the states facing those damages? For me, this is unacceptable. And we need to think about the consequences first. So I was invited 2 years ago by France and Senegal, who are the focal point for cooperation in the Hague Working Group. And this was a conference in Paris. Delegate was surprised when I gave my point of view, saying, can we, with a certain impunity, violate the Rome Statute itself? Please change the Rome Statute. Linked to the crime is without any ambiguity. So I will finish my remarks before giving the floor to Michael, who will enter in the detail. My first proposal is that we should have in ICC not only an investigator in charge of trying to cooperate with international police to identify some means or assets. We should have or create a post, a senior post of administrator in ICC, in order to have someone liaising with the states and to try to preserve the asset and the means for the future. In case of conviction, to have something for the victim in case of reparation, but to preserve the means and the value. And Kate was insisting on this point. What about the value of the asset and the means? So first suggestion is to have inside ICC a senior post of administrator. The second proposal, it's linked to legal aid. You know that when we have a suspect or an accused in ICC, there is an assessment to know immediately if this person is or not indigent. In OPCD, we think that international procedures have nothing to do with the domestic one. The Bemba case is an example. 10 years of a life. It's very rare to have it at the domestic level, so everything has to be exceptional. My proposition as a principal counsel is that we should consider based on the presumption of innocence, that the international community should take its responsibility for all the proceedings, fees for counsel, defense teams, defense counsel for victims, everything has to be taken by the international community. And after, if you have a conviction, then the international community or the court will try to compensate that, because it's totally unfair for someone. Look, Mr. Bemba, of course, he was the first declared indigent in the court. And this is for the public. Do you know, dear public, that the cost of a defense team, a normal defense team, the cost of the fees per month are 35,000. Who can afford it? I remember in Nuremberg 7 years ago, we have a panel discussion with some judges, and one of the judges, member of the leadership of the court, I told this judge, Excellence, do you know that you and me, we are indigent? So the judge was in trouble. Yes, an ICC judge is indigent. Who can afford to pay 35,000 per month just to defend or to prove your innocence? That's impossible. So the last suggestion is very important, is that legal aid should be generalized and no fees, even if you are non-indigent, no fees until being convicted. I will stop there and give the floor to Michael. Thank you.
Thank you, Mr. Keita. And just Michael, you have about 10 minutes to intervention.
Thank you, Ricardo. I will try in those 10 minutes to shed a little bit of light on what Mr. Keita has said about the asset management framework as far as one exists at the ICC, because it's, as you can tell, probably not the clearest. So I want to start with what is expressly in the Rome Statute and some of the practices and the case law, before making comparisons perhaps with some of the other international cooperation models and what they can say about where liability might rise, in a very general sense, not connected to any particular case at the ICC. So the power is in there in the Rome Statute, Article 93, for the court to request states to freeze and seize assets. The way it works is it's usually issued as part of the arrest warrant, the request is made, and it's up to the state to use its national procedures to implement it domestically. Now, one of the issues is it's nowhere in the Rome Statute where it's expressly regulated how or who should manage the assets or how the liability works. And there is a question about whether that might be implied or there are inherent powers in that regard, but that's in the Bemba litigation, Mr. Bemba's litigation, so I can't really go into that whilst it's pending on appeal. But I think there's other ways to potentially address this question about liability and who should manage. Now, first of all, the court itself has acknowledged that it's a good idea to make sure that the assets don't devalue. It said in a publication, an extrajudicial publication, 2017, November, on the freezing of assets, that they should be not allowed to devalue, and that consultations with states at the very early stage is crucial to avoid them from being devalued. So the court thinks it's a good idea. Can it be done under the existing express statutory framework? And I think probably yes, because under Article 99 of the Rome Statute, it says that when the court makes a request to the state for cooperation, it can stipulate how it should be done. It can stipulate the procedures that should be done while exercising it. So there's nothing stopping the chamber from saying, please freeze these assets, and also could you please make sure that they're appropriately managed under your national laws. And in fact, we saw elements of this in some of the earlier arrest warrants, where the court made at the same time as an arrest warrant a request to freeze the assets, And it also asks the states concerned, please tell us if you appoint the interim administrator. But it was framed in that sense, not as a requirement. But there's nothing, I think, stopping the chamber from going a bit further and making it a requirement. So that's how it generally operates at the ICC. So if we look at the international cooperation models, what can we learn from them? Well, it's not just the ICC that's making cross-border requests to freeze assets. It happens all the time. States make them all the time with each other, and there are quite developed models on this. The main model, the classic model, is international cooperation, international legal assistance framework. Usually mutual legal assistance treaties are signed between states. You can also find them in conventions like the UN Convention against torture, against corruption. And now they don't really have, it's been the growing norm and the accepted norm that states should have asset management features in place for those, but there isn't really much talk in those types of arrangements about who should be liable if it goes wrong. But there is a newer model, which I suggest may be more helpful to consider, and it's called the mutual recognition model. It's operating now in the European Union framework, and it says, instead of you having to then go to the executing state and going through all the steps there to get a freezing order made, let's say you have two states, you have Germany and France. And if a German court orders assets to be frozen in France under the mutual recognition model, the French authorities can automatically recognize that. And this is because there is a greater mutual legal trust between those two states. But the condition of this type of arrangement is that if something goes wrong or there's damages that arise from its execution, then the state that requested it is liable. So can that teach us something about how it might work at the ICC? Possibly. Now the ICC has its own unique cooperation model, but it has elements potentially that look a little bit like a mutual recognition system. And I think Dove also mentioned there where what it does look like. So perhaps there's lessons to be drawn there from other international cooperation models. But I also want to mention about the uniqueness of the ICC. And this has also been, I think, one of the issues. And the court has highlighted that while there are lots of existing national mechanisms between states and domestically for carrying out cooperation requests, one of the issues is when a state receives a request for cooperation from the ICC, these existing national mechanisms are not used for whatever reason, maybe because the ICC is very novel and states don't quite know what to do with an ICC cooperation request. So this is where my previous point goes back to Article 99. The chamber can stipulate when it makes the request how it should be exercised. And it can, in my view, also make a request to the state to use these existing national mechanisms. There's nothing stopping it. So perhaps these are the main points that I have to explain how the cooperation system works in terms of freezing of assets at the ICC and how the asset management framework works. But I'll just finish on another point, and that's what Mr. Cater said, and what Kate also mentioned. So the power to freeze assets is a very powerful one, and with the greater, with such great power, usually you would want to have great responsibility in exercising it. And we at OPCD, we've tried, as Mr. Cater has said, to restrain this power somewhat. And when we were invited to make submissions on this in the past and on asset freezing, there was a question on whether you can freeze assets, the entirety of the assets of a suspect, or it should just be linked to the crimes. And we tried to say it should be linked to the crimes only. Now the chamber disagreed, the appeals chamber disagreed and said you can freeze the entirety of a person's assets. But I think the consequences of this kind of decision means that the harm that is caused by the asset freezing is greater than it would have been had it just been assets that are directly linked to the crimes. So with greater powers that are wielded, then I think there should be greater responsibility exercised by the chamber, and this Article 99 option of making sure that the chamber is the one that pushes the states to ensure that assets are managed according to existing national mechanisms is one that should be considered.
Thank you very much, Michael, and that pretty much covers all interventions. I would remind all attendees that you may pose some questions in the Q&A feature that Zoom has and that you can access in the lower part of your screen. For now, we have one question. I'm going to just ask a couple of follow-up questions for the panel, and we'll start taking questions, see if some additional questions are posted. So, well, I would say for the most part, or maybe two of the main things that have been mentioned or discussed in the panel are the, let's say, lack of clarity in terms of the evidentiary standard for, you know, determining whether there has been a miscarriage of justice, and as Mr. Keita mentioned, the lack of definitions thereof, and so on, also in relation to what are those exceptional circumstances that would lead to such a ruling. So my question is, do you think should this be left open to interpretation for the judges, or should there be more clarity in terms of what is it that constitutes a grave and manifest miscarriage of justice, particularly considering that's the high threshold that states decided to include in the statute? And then related to Michael's presentation, my question is, if there's no clear framework in the sense of who manages the frozen assets, and considering that the court said basically we don't have jurisdiction to rule on this because it's not provided as such in the statute. So what option did the court have in deciding how it decided? Is this something that requires the framework of the statute to be changed, or and where does the liability rest? Because so what about the liability of the states in the territory of which these assets were being maintained? And so how does that let's say interplay of responsibility, how can that be expressed in a way that ensures that these kind of situations are not repeated in the past? And of course, any panelist can it's an open question for the panel, so feel free to take the floor.
Can I try perhaps with the second question?
Sure.
So, well, part of Mr. Bemba's claim is that there are inherent duties on this. So I won't go into that. But when there's a lack of clarity in the Rome Statute, you can go back to Article 21. Article 21 says what's the hierarchy of laws here, and you can, as part of that, in the event of a lacuna, look at what is the international practice. And then at that point, when you look at the international cooperation models, you ask yourself the question, well, what is the ICC cooperation model? Which one does it look like most? And that's when you can go back to mutual legal assistance models where that, I say, doesn't help so much because there isn't so much clarity on who's liable. But if it looks enough like the mutual recognition model, then there's nothing stopping the court to say, through Article 21, we've looked at this, there's enough elements there that we say we can use, and then develop it through the case law. So I don't think there's anything stopping the court from saying that. It's done it quite often in the past in respect of other issues. But it's a question of, the issue is the ICC has a very unique framework. So it's not, there's no simple answer to this. You can't look at another model and say, this is how it should work here. You have to take into account the things that look like that model and the things that don't. So there's no clear answer, but is there jurisdiction for the court to potentially entertain this type of thing? Well, that's one issue that's in the Bemba litigation, so I can't really go into that in respect to that because I think it's quite similar, the question that you're asking, as to what Mr. Bemba is facing now.
If I can jump in on that question as well. In Mr. Bemba's claim for compensation, which we filed 6 months after his acquittal within the time frame, we sort of set out this compendious review of domestic and international precedent in relation to freezing orders. Bemba's lead counsel, Peter Haynes, and I were in no way experts on international cross-border freezing. We came knocking on Michael's door for help, but we spent a lot of time and spoke to a lot of people who know a lot about these things. And our position, we arrived at the same position as Michael has arrived at, that in these sorts of situations, you have a requester and an executor, a requesting state and an executing state. And in those situations, if something goes wrong and liability or harm arises, it's the requesting state that needs to indemnify the executing state. And so, you know, the analogy is easy to draw in relation to Mr. Bemba's assets, we believe. But in terms of your specific question as to whether there needs to be any sort of change to the framework of the court itself when it comes to seizing and freezing of assets, I don't think it's something that necessarily needs to be written into the constitutive documents of the court. But obviously the practice needs a wholesale sort of overhaul, you know, starting with requests for cooperation themselves. Obviously these are confidential documents. They pass between the states and the court, and the accused, the defendant, doesn't necessarily have access to them. But if they're being framed in a way that clearly delineates liability in relation to destruction or decrease in value of the assets, then we have our answer. If they're not being framed in that way, and these sorts of things aren't being dealt with, then maybe that's a first step. There needs, because, you know, as Michael said, this happens a lot. The process of freezing assets in other jurisdictions and in cross-border jurisdictions is very, very, very carefully managed. There are protocols in place, directives in place, there are procedural safeguards that govern things like indemnities, liabilities, duties in relation to that property. And, you know, the European Parliament has a directive on the administration of seized assets. The G8 has its best practices. UNODC has a directive. The Council of Europe has a convention on it. It's something that a lot of people have thought a lot about for a number of years to try and avoid exactly the situation that happened when the ICC just sort of dove into this without even a protocol or a directive or as far as we know, any kind of clear understanding and delineation of liability. So in short, I don't think we need to rewrite the Rome Statute on this point, but I think that practically things need to be done in a way that doesn't end up with the Bemba predicament.
Okay, Bob, go ahead. Yeah.
So just a couple of points on the questions you asked. I agree with Xavier Jean about the lack of definition, but, you know, to be honest, this is a problem that we face daily with the ICC, and that even domestic jurisdictions face whenever you use the word justice or reasonableness. You know, what is, I mean, I won't go into the debate that we've had for the past 2 years in relation to the Afghanistan decision and what are the interests of justice, how do you define them, etc. So I'm not sure it's actually possible, save for having a clear provision that if you're acquitted, you get compensation. That's simple, right? I mean, there's no discussion about thresholds and discretion, etc. But any other solution will necessarily carry some element of vagueness and interpretation. The problem we have at the ICC often, and to put it bluntly, is that doubt rarely benefits the accused in those situations. You know, when it comes to interpreting evidence, when it comes to interpreting justice, when it comes to interpreting miscarriage of justice, you will often have decisions where judges will say, well, on balance, we're not going to find in favor of the accused because, you know, we're using our holistic understanding of whatever we're discussing, whether it's the evidence, whether it's Article 85, whether it's something else. And that, you know, holistic understanding of whatever they're studying often turns out to be not in favor of the accused. So that's a problem, you know, in practice. But I'm not sure we can actually define miscarriage of justice without having some room for discretion. And the second point on freezing of assets, I think it's, given the complexity of the issue in terms of which jurisdictions will be considered, you know, domestic jurisdictions, European jurisdictions, ICC, I'm not sure there is a one-size-fits-all solution. Even if there was a provision in the Rome Statute, this doesn't mean it could be implemented directly before a domestic court, for example. No, you would still need to see how this kind of freezing works domestically. So I don't think that the reform, what the ICC needs to do is take responsibility for its own actions. But I don't think that the Rome Statute can be expected to provide for the responsibility of states under domestic law. And you can even have situations where, you know, the Rome Statute might provide for one legal solution and domestic law might provide for another one, and it's not compatible. So I think it's more complex, especially in a situation where nobody wants responsibility, whether it's ICC or states, because a lot of what you said, you know, presupposes goodwill and good faith, and there is not a lot of that in such a situation. So.
Thank you all. We have 5 questions. I don't think we'll have the time to answer any more questions than that, and let's see if we manage to answer those. So I'll start with the first question that was asked during the discussions, the initial discussions. The question is whether there is data available on how, and this question may be for Michael, how frozen assets have been handled in other cases in terms of comparing the value of the asset the moment it's frozen and the value of the asset at the end. And so the effect that the passing of time and mismanagement could have on the assets themselves. Is there any sort of data available or any precedent on how this has been taken into account or not?
As far as I'm aware, it's only been in Mr. Bemba's case where this type of information is been discussed to the extent that it has discussed. I'm not aware of there being any other data made public.
I will say difficult to have data. Mr. Bemba was the first declare non-indigent, and the other non-indigent was the Kenyan high-level vice president of Kenya and president of Kenya. So let's say if you have indigent people, you don't have something to freeze. So difficult to have data. So no precedent. I think that the Bemba case was the first, and who will have data after this Bemba case.
I will say though, in the domestic jurisprudence and cases that we reviewed in putting together this claim, it's not so much a matter of looking at this business was worth $1 million at the beginning and $500,000 at the end, because the fiduciary duties that attach to the requesting state or the requesting party are continual, and there'll be reporting obligations, procedural safeguards to ensure that the court is getting a regular flow of information as to the fact that the business is being maintained at the value, at a particular value. And if it drops below, the person who's the party that's requested the freezing is required to take steps and perhaps reinvest funds or take steps to make sure that the value is always maintained. It's a very, very, very complicated process when it's done properly.
Thank you. Thank you very much. We have a second question. I'll read it. And the question is, states parties have been asked to deal with the issue of non-existence of time limits of the proceedings. Revising the statute is a lengthy and cumbersome proceeding. So could, for example, changing the rules of procedure and evidence do the trick? And how do you think the independent expert review will deal with this decision? Dr. Jacobs.
Yeah, no, that's a question you asked actually. I'm always, obviously, and the pretrial chamber said so, 10 years is long, but I'm always very wary on the people commenting on the outside on the objective length of proceedings at the ICC. And people who are involved in them on a daily basis realize that these proceedings do take some time compared to domestic proceedings. So I'm always careful in saying that, X number of years is per se objectively too long. One other risk you find in this kind of discussion is that people are balancing defense rights against each other. So, and that I think is a real problem and a trap that you often risk falling into in this whole review exercise, is that, when the defense team asks for extra time to file a motion or to review evidence, the answer by the chamber is yes, but this goes against expeditiousness. And so expeditiousness, and this is maybe a controversial view, but expeditiousness has been expanded from what is basically a right of the defense into a more managerial concept. Things should be fast in the abstract. Things should go fast independently of what's going on. And that's a big risk, because when a defendant is told, no, I'm not giving you more time, even though you've demonstrated that you need more time because you have a small team to review evidence, etc., you're throwing back a defense right to the accused to prevent him from exercising a defense right. And you often see that, we have to balance expeditiousness and blah, blah. And there's no balance. When the defendant is trying to exercise his right, expeditiousness is not an issue. It's a trick, it's a semantic trick to pretend that, this is politically correct. We're doing this for the accused. No, so if the court wants to use managerial concepts, it should not use the word expeditiousness. It should use something else. It should accept that it wants to do things fast, independently of the exercise of the rights by the accused. So sorry for this rant, but this is related to the question. Any discussion of expeditiousness which doesn't write clearly that expeditiousness cannot be limited, or speed cannot be done to the detriment of other rights of the accused to have time and facilities to prepare his defense, etc., would not be a good solution. Yeah.
Thank you. Okay, you wanted to say something else? Thank you very much, Dov. The next question is, to what extent would the system of frozen assets management be improved by the process being dealt with inter partes, including representation from the defense and the victims rather than ex parte? As I understand, they were substantially in the Bemba case. That's the question we've been asked.
I mean, that's a bit of a double-edged sword, because I think that certainly the accused should be able to have some input into what happens to his businesses, his homes. I think if he could work collaboratively and assist and have some understanding of the picture of what is being frozen, of what is being seized, of where it is, of who's in control of it, that would certainly assist. But I wouldn't like that to be used against an accused. The registry was very clear in asserting in our case that in its view, Mr. Bemba should have been managing these assets himself, and suggested in the oral hearing that, that he would have an ability, and he should have done more, in fact, to ensure that the value didn't drop. And I think that's unrealistic. I think someone is in no ability to take concrete decisions when they are incarcerated with no sort of provisional release. So I'm very wary of that argument, but at the same time, I think certainly, Mr. Bemba was kept completely in the dark, as was his team, in relation to concretely what was happening with the assets that were subject to the freezing orders. So I think greater transparency could certainly assist.
Thanks so much. The next question is, some of you, so I'm going to read the question. I'm wondering why you propose to administer the freezing assets by the court based on domestic European standards. And so this relates to the other instruments that deal with these sort of situations.
Can I try to answer that? I mean, it depends what you mean by the court administering the frozen assets, but generally the framework is that the court requests the states, and the states use their national mechanisms to do that. But that actually, it's a good point. Maybe sometimes states either do not have the capacity to administer frozen assets, then should the court perhaps step in and do it. And that is also potentially an option. It's not provided for in the Rome Statute framework, but it is potentially possible. But generally speaking, there are existing national mechanisms already in place for interstate freezing orders. And the main issue at the moment, and the main challenge we're facing, is making sure that the ICC cooperation requests that they use those national existing frameworks for cooperation requests. But I don't see there being a problem in the future if you want for the court to step in as well. I don't know what the other panelists think about that, if for some reason the state itself can't do it.
Thanks, Michael. Any of the other panelists wants to add something on this? All right. And so I think we have time for one more question. Actually, there are two questions, but I think one of those was already addressed. So I'm gonna ask the second question of this last participant, and that is, how could we interpret the wording of Article 85.3, specifically where it says that the court may, in its discretion, award compensation? Are there plausible alternatives to admitting that the court has discretion even when the threshold has been met? And this has to do with also, related of course to your presentation, Bob, where you mentioned that this remains an alternative for the court even when the threshold has been made. So what could be thought or proposed in that regard to maybe avoid that possibility? And is that an outcome that would be desirable?
No, I don't have much to add to what I said before. I mean, you know, the language of 85.3 is the language of 85.3. It does suggest discretion. My question was maybe a bit flippant, is that I'd like concrete examples. It's always a question of legal certainty. You know, when you're a litigator at ICC, whether defense or prosecution or victims, it's not even a defense issue. You want to know what's going to happen with what you do. You know, you want to, you know, the legitimacy of the court, of its case law, depends on being able to some extent, not predict every outcome, obviously, but to have some legal certainty about how a claim, whatever the claim on admissibility, on reparations, on witness preparation, anything, will be dealt with. And one of the bigger challenges for the review is to try and bring some form of coherence and predictability in the ICC's case law. I'm sorry, I'm generalizing the comment here, but this is a general problem at the ICC. You know, from one trial chamber to the other, you don't have the same case law on admissibility, on witness preparation, on how do you interrogate our witnesses. So here I would make the same comment, that I can't rewrite Article 85.3 and wish away the discretion. My problem is, how is it applied? And this was an opportunity for the pretrial chamber, rather than make general statements, to actually give us examples and guidance. It might not have helped the Bemba defense team, you know, in this case, but at least it would have given other defense teams in the future some clarity and some predictability on how the legal framework will apply. And I think, again, this is you know, a key aspect of legitimacy for any court, and also for the International Criminal Court.
Thank you very much. And unless there is any additional comment by any of the panelists, I think with this we reach the end of this event. I think it was very interesting. I really thank all of you for participating. Of course, the panelists for taking the time in answering these very important questions, and all the participants for attending. And with this, we conclude the event, and we'll see you next time. Thank you very much. And Kate, I think you want to say something?
I was just going to say thank you very much.
Thank you.
Okay, yeah.
Thank you for inviting us.
Yeah.
Thanks. Great.
Thank you, Ricardo. Good to see you again.
Thank you. Thank you. See you next time.
Bye.
Bye-bye, Kate.
Bye.
A bientôt, Dove.